$1,500 for an 8-year-old child's birthday celebration. When the father declined, the core conflict shifted beyond the party itself. The mother petitioned the court to mandate child support, not because the minor lacked proper provisions, but driven by a single costly choice: a private skating rink and a guest performer. And once this matter reached family court, Judge Vonda B established a definitive principle: child support is never a mechanism for financial reimbursement.
Jackson?
Yes.
You brought this case before the court.
I did.
Okay, what's going on?
So James and I split about a couple of years ago, and it's been pretty good. We've been splitting costs for our girl, but her last birthday she was 8 years old, and we had a great party. I planned it. It's been a lot of time, and it was about $1,500.
How, 8 years old?
Yes. Well, okay, she really likes, ice skating, so we rented out the ice skating rink, and then Tara Lipinski came and did a little routine for the girls. It was a lot of fun. But anyways, it did cost something, and James just refused to pay it.
This legal proceeding begins in a setting familiar to numerous households. Both parents share physical custody. No formal child support mandate exists. Each individual finances the child's daily expenses throughout their designated parenting periods. Lawfully, this qualifies as an equitable structure. And based on all evidence, the arrangement functioned successfully until one parent enacted a unilateral monetary choice devoid of mutual consent.
Whose idea was it? Wait. How much was the birthday party?
$1,500.
Whose idea was it to have that expensive birthday party?
Tyranny brought up the whole inspiration for it. So I just kind of, looked at what past birthday parties we had gone to, kind of the expectation was set at a certain level, and yeah, so I did ask James for certain input, and he did not give that, so I just took that as I have to parent up.
So you want him to pay child support now?
Yes, I think this is kind of it's changing up the dynamics a little bit, that he wouldn't even pay for a little bit of her birthday party. So she's getting into ballet. There's recitals coming up. There are other things coming up, and I'm just nervous that she's going to see that imbalance in our relationship, and it's going to cost something.
Here lies the critical legal turning point. The objective of this motion is not dividing a birthday invoice. The goal is establishing permanent child support grounded in a singular discretionary expense. That represents a fundamental shift. Child support exists strictly to satisfy essential youth requirements: housing, nutrition, education, and medical treatment. It is not structured to recoup funds spent on optional or extravagant gatherings. This distinction remains vital, which the judge clarifies immediately.
You're creating the imbalance. $1,500 for an 8-year-old birthday party?
That doesn't sound, it sounds bad when you say it out of the context, but that's normal.
Within the context, that is ridiculous.
That is normal.
No, it's not normal.
Susie had a birthday party that cost $2,000.
So you're trying to keep up with Susie?
Well, I didn't do $2,000. I could have done $2,000, and I think I kept it at a reasonable cost. She got to meet Tara.
Wait a minute. Pause. Can you speak some reason to me?
I would love to try, Your Honor. I am more than happy to help our daughter celebrate and live her life, but there comes a point where it's just, it's frivolous, it's opulent.
I agree.
I would have been fine going halfway down the middle of just like paying to have some kids to the skating rink, but we did not need Tara Lipinski there. I thought that you were joking when you said that, which is why I didn't respond.
I do not.
At this juncture, the court provides a necessary distinction. Expenditures by other guardians or socially accepted norms do not dictate legal duties. Luxury remains a personal preference. The judiciary does not compel parents to match alternative spending habits. Without prior joint agreement, a single parent cannot impose a financial liability onto the other retroactively.
And you know how...
Excuse me. Last time I checked, I was the judge. So I would like for the two of you to address me.
Thank you, Your Honor. Sorry.
You're welcome. You did not need Tara there.
Tierney really wanted her, though.
Yeah, but Tierney is not paying $1,500, is she? No, and it's absolutely ridiculous that you have the expectation of him to pay that when it was your idea. That is ridiculous. And you came to court today to ask me to do what exactly?
I just want in the future to make sure that there is a balance in our relationship.
I'm going to ask you again. What is it that you came to court to ask me to do?
I would like him to pay child support.
The father's stance is legally sound. He never neglected his parental duties. He demonstrated readiness to fund age-appropriate shared developmental activities. His refusal applied solely to an extra cost that lacked prior discussion or joint approval. Family courts consistently acknowledge that cooperation does not equal boundless financial accountability.
Well, I would like for you to not spend $1,500 on a birthday party. The 9-year-old, when she turns 9, no $1,500. When she turns 10, no $1,500. I mean, that is absurd. And then you want him to pay you child support because he did not want to go in with you with this ridiculous amount of money you spend on a birthday party? Yeah, no, we're not doing that. I'm not going to have him pay child support based on that. And you guys have been sharing custody. So I'm assuming when the child is with you, you cover the expenses for the child, right?
And it's usually really amicable. It usually works really well, but...
Well, it sounds like she probably put herself in the hole with that $1,500 birthday party and is trying to recoup some of the money from it because you were trying to keep up with Susie paying $2,000, which is absolutely ridiculous. And I'm not going to do it. And I cannot believe you actually filed this in court and asked me to do it for those grounds. Yeah.
I see that there's no weird issue with this thing. Okay.
Well, it's just, I'm happy to help. I'm happy to step in and help our daughter pursue her interests. If she wants to do ballet, sure.
Ballet makes sense. Ballet is an activity.
Right.
If she chooses to do ballet in school, I mean, it's an educational activity as well. But I am not going to order anybody pay child support based on a $1,500 birthday party.
When parents divide custody and expenses evenly, opting to surpass standard budgets becomes an individual duty. Tribunals will not transform personal financial regret into a mandatory support obligation. Child support looks forward. Its purpose is safeguarding the youth's welfare, rather than rectifying past purchasing decisions.
And you guys share custody. Who pays health insurance?
We both do.
Yeah, I mean, that's the only thing you guys should be doing. Maintain your own individual health insurance, but no, he is not going to pay child support for that reason. Okay?
Okay.
All right. Is there anything further?
I don't believe so, Your Honor.
Okay. Is there anything further from you?
I'm good. Thank you.
Okay. Well, I'm glad. If there's nothing further, you both are dismissed.
The court rejected the motion. Joint custody stays active. No monetary support was mandated. This dispute emphasizes a crucial standard. Fiscal cooperation demands clear communication, avoiding post hoc legal battles. What are your thoughts? Should magistrates ever intervene regarding discretionary costs? Or did the judge apply statutory law properly here? Leave your opinions below and subscribe for further judicial breakdowns. A mother petitions the court to regain custody after her minor child has resided with the father for nearly 5 years. She clarifies that the separation stemmed from a domestic abuse situation she successfully escaped. Yet her petition extends beyond custody. She concurrently demands child support from the father who has maintained full-time care. Subsequent events prove critical because this litigation illustrates how custody and support function within domestic relations law. And as Judge Vonda B breaks down the details, the final ruling surprises many observers.
Laura,
Yes, ma'am.
you brought this case before the court. What's going on?
I'm trying to get my baby back.
Okay.
I have 2 babies,
Okay.
and I just had another baby with my boy. He's not my boyfriend anymore, but he hit my first baby, so Houston got to take him, and I want him back because I'm not with that boyfriend anymore.
So Houston took the baby or you lost the baby?
Either way, Houston has the baby, and I want it back.
No, it's not either way. It's you lost the baby. So somebody intervene and take the baby away from you? And
Yes,
give the babies?
ma'am. They took the baby and gave him to Houston.
Okay.
And I want him back.
Okay.
At the trial's onset, the magistrate highlights one fundamental fact. The minor is neither missing nor newly relocated. The child has lived alongside the father since early childhood. Within family court, emotions hold weight, yet stability holds supremacy. That specific factor instantly dictates judicial perspective regarding the case.
And you have a new baby with your ex-boyfriend?
Not ex-boyfriend, ex-boyfriend.
So you guys are no longer together?
Correct, ma'am.
How old is this new baby?
How old's the new baby?
Yes.
Like 8 months.
And you're done with him after 8 months?
Yes, ma'am.
Okay.
I was done with him like 10 months ago. The baby's 8 months.
Oh, okay. So before the baby was born?
Yes, ma'am.
Did he come to the birth of the child?
No, I didn't want him around.
Oh, okay. All right. So you now want to get custody back from him?
Yes, ma'am.
Okay.
From Houston.
Who does the baby live with?
Me.
The baby? No, my baby lives with me.
No, not your child. How many children do you all have between you?
Just one.
Just one. And the child lives with him,
Yes, ma'am.
and you want the baby back.
Yes, ma'am.
How long has the baby lived with you?
The baby has been
Yeah.
living the whole time.
Oh, okay. And how old is this child?
5.
5. Oh. And you expect to get child support,
Yes, ma'am.
and the child has been living with him for almost, it's a boy or girl,
Boy.
his whole life?
Yes, ma'am. Well, when I get my baby back, I want child support. Yeah. He makes way more money than I do. I want my baby back and I want child support.
This constitutes a vital legal distinction. Claiming custody and requesting child support represent two distinct legal concepts. Child support relies not on parental desires. It depends upon who physically houses the youth and provides ongoing daily custody. Demanding financial support prior to modifying custody arrangements is deemed impractical by the court.
I'm sorry, you have to excuse me because nothing you're saying is making sense right now. You came to court to ask me to give a child back to you that was taken from you, that's 5 years old, that's pretty much lived with this man the entire time that he has been taken care of.
They took my baby away because my ex-boyfriend is an abuser and I'm not with him anymore, so I want my baby back.
Right, but the child hasn't been living with you. The child has been living with him.
Yeah, because of my ex, and I'm not with my ex anymore.
Yeah, so no, it doesn't work like that. It doesn't work like that. He would literally have to have given you the child back. And then you come in here, after you've been having the child for some time, then you come in here and say, Judge, I want this to be changed. I've been having the child this entire time. I want him to pay child support. That would be a little bit more reasonable. But what you're asking for today is very unreasonable.
Okay, well, give me my baby back, and then I'll come back in a while and ask for child support.
Well, I can't give you your baby back because I never took.
The judge underscores the timeline here. 5 years. Legally speaking, this denotes long-term permanence. Family tribunals refuse to overturn living situations merely because a parent's personal circumstances improve. The bench examines primary residence, daily care provider records, and consistently functioning schedules.
Okay, actually, nobody really took your baby. You lost your baby for your own negligence with your ex-boyfriend. That has nothing to do with me. Okay, now, fill me in over here. The baby was placed with you after the boyfriend hit the baby.
Yep.
And he's been living with you ever since then.
Yep.
You've been taking care of him.
Mm-hmm.
You pay for everything for the child.
Everything.
What does she do?
I visit.
She visits unsupervised.
Okay, congratulations. Financially, what does she do?
Financially?
Yeah.
Nothing.
Oh, that's what I figured. Okay, I see what's going on here. Yeah, and I'm not about to play this game with you. You're the one that's going to pay him child support
What?
today. Yeah, you are.
This phase illuminates the monetary realities. The father verifies that he covers housing, nutrition, health insurance, and everyday upkeep. The mother acknowledges visiting the minor yet admits supplying no fiscal backing. Courts depend extensively on these verified facts, rejecting unproven allegations and stated intentions, focusing solely on demonstrated accountability.
He makes like 3 times as much money as I do. I have to give him my money?
It's for the child, so yes, you do. You do. But the good thing is based on your income. You'll get credit for the other child that your 8-month-old, you'll get credit for that child. But yes, you are going to pay him child support. That's just the right thing to do. It's one child between the two of you, okay? And health insurance, I'm assuming you pay it.
Yes.
How much is it?
$66 a month.
$66.
I get it through my
Okay.
employer, so.
Huh?
I get it through my employer.
Okay, gotcha. And how much do you make a year?
$38,000.
38,000. So I have your gross coming out to $3,200. That brings your net to $2,648.01. Giving you credit for the other child that you have. Your child support obligation comes out to $423.69 plus the $66 you're going to reimburse him for health insurance every month. So 66 added to 463.69 is 489.69.
This point catches numerous viewers off guard. Child support follows the dependent, independent of income tiers and gender. Since the minor resides with the father, the mother functions as the non-custodial party. Consequently, she remains legally bound to contribute financially despite the father earning a higher salary.
$489.69.
Did you need me to repeat it?
I'm asking you, $489. I have to give him almost $500 a month.
Yeah, that's how it works. Did you really think that I was going to have him pay you child support?
No, I just wanted my baby.
Oh, okay. So your first answer was no. So then you understand exactly why you have to pay child support. Is there anything else?
No, ma'am.
Okay. Is there anything else?
Nope.
Okay. You all are dismissed.
The judge evaluates the financial metrics sequentially. Earnings, medical coverage, and deductions for additional dependents factor into the computation. The final figure serves no punitive purpose. It merely reflects the application of statutory support guidelines to proven facts. This trial demonstrates a core lesson regarding family jurisprudence. Custody rulings favor consistency over timing. Escaping abusive circumstances remains crucial, but it does not automatically reverse years of established living arrangements. Tribunals prioritize permanence, documented caregiving, and the child's daily lived environment. Do you believe the bench correctly applied the law here, or should emotional context outweigh established facts? Post your thoughts in the comments.